Chief Justice, Attorney General, honourable members of the Judiciary, President, Dean, staff, esteemed guests and fellow students. Today, we are marking a momentous occasion, the celebration of a decade of teaching, learning and growth within our law school. For 10 years, this school has shaped the legal landscape both in Ireland and across the world. For 10 years, we have served as a beacon of knowledge, integrity and innovation. For 10 years, we have shaped the minds of future legal professionals and fostered a commitment to justice and the rule of law within them. As the first person in my family to attend university, I could never have imagined the opportunities that were waiting for me here in UCD. At the start of my degree, I was working 12-hour shifts on the weekends in order to support myself, until I was fortunate enough to receive the Cotram na Féine Scholarship and could focus more on my studies and making the most out of my time here in UCD. Now, I have studied in areas that I'm passionate about, made incredible friendships that will stay with me for years after I graduate, and created memories that will last me a lifetime. Sutherland has always been my home on campus, and the law school has been an invaluable support to me over the last 3 years. Whether I was knocking on lecturers' doors to ask them a question, or grabbing a cup of hot chocolate in the atrium with my friends, the law school has always catered towards my student experience. From our exceptional faculty members whose dedication to teaching and mentorship has inspired generations of students, to our diligent staff whose unwavering support ensures the smooth operation of our programs, they have turned Sutherland into the incredible success that it is today. As someone from a rural, low-income background, the first semester of my first year here in UCD was difficult. Like many students who enter UCD through the access pathways, I struggled with imposter syndrome. I doubted my capabilities and whether or not I would really belong here. That was where the law school stepped in. The range of supports that were available to me, and everything from my student advisor and my peer mentor to the Students' Union and the Access and Lifelong Learning Centre, ensured that I know I have a place here in UCD. Above all else, it is through the passion, curiosity, and potential of our students that our true success is found. The students are the future leaders of the legal profession and the embodiment of everything taught here. When I look ahead to the future, I am filled with optimism and excitement for the opportunities that are out there. Because of the exceptional education that I've received here, there is endless potential. Long after my graduation date, the law school will continue to push the boundaries of legal education, pioneer new pathways, and forge new connections that will shape the legal landscape for generations to come. And even though we are climbing the ladder of success, we need to remember to give a helping hand to those who come after us. That is what makes UCD a university for all, and is what makes Sutherland a perfect place to study law. Thank you.
Staff, fellow students, and welcome guests. As a student that spent his first year attending UCD huddled over a laptop in his garage, this building holds a particular significance for me. Since the first day when I got to leave that garage and actually come into the law school, Sutherland has always stood out to me and my fellow law students as our home on campus. Even a decade after moving into the building, guests always remark on the state-of-the-art facilities that we as staff and students have here at our disposal in the law school. Whether it's attending lectures in theatres such as this one, or developing our advocacy skills in our unrivaled courtroom, this was a building that was clearly built to enhance the student experience. And even beyond academics, the law school, both the people and the building, have always been an invaluable resource in developing the student experience here. One of my core memories that I've built here in UCD was when I was elected as auditor just across the atrium. The law school stands out as the envy of most of campus, and as law students, we have the pleasure of calling it our academic and social base. The Sutherland School of Law is an environment that fosters collegiality and learning in a way to best prepare us as the lawyers of tomorrow. When we come to UCD for our academics, we often take it for granted that we are coming for the best of Irish legal education. We take it as given that our lecturers have written most of the leading textbooks and are leading experts in so many areas of Irish law. And despite our numbers as students, we are never merely faces in a crowd. Students in the law school are always recognised as individuals, each deserving of genuine care and support from our dedicated faculty. And it is this catered, caring approach that sets our educational experience apart, creating an environment where every student can thrive. And that sense of community spans well beyond our 4 years here in Belfield. As a student, if we are ever organising moots, debates, academic events, or social events, we always know that we have a remarkable pool of alumni who are always incredibly generous with their time. It's now my pleasure to welcome President Feely to speak. President Feely became UCD president in May 2023, having previously served as vice president for research. Her core discipline is engineering, and she's president of CSER, the Conference of European Schools for Advanced Engineering, Education and Research. A member of the board of IBEC, the president also holds fellowships and memberships of several scholarly and engineering bodies, as well as being a member of the Royal Irish Academy. Welcome, President Feely.
Thank you very much, Aisling and Robert. It's a great pleasure always to welcome people to our wonderful campus and to the wonderful Sutherland School this evening. As you've just heard, the building is celebrating 10 years. Pick up a copy of this brochure if there are any still going around. And it's such a wonderful facility. And, you know, I'm struck by the fact some of our buildings, almost as soon as they're opened, they seem to date. This one feels to me still like a very fresh new building. And I think that that is a testament to the great work that went into creating it back more than 10 years ago. I know very, very many people were involved. I always associate Imelda Marr in particular. Is Imelda around? She's around somewhere. No, there she is. But I associate Imelda in particular with pulling together the vision for this building, because I think the vision was ahead of its time. It was the first purpose-built law school in Ireland, and it was ahead of, you know, where we currently are in terms of very active learning for our students, in terms of technology-enabled learning. So I think that we are greatly indebted to all those who came together to develop this facility. The donors, the friends of UCD who funded the building, that was very, very important in making it a reality. And of course, to the late, great Peter Sutherland, who was so generous in his support of the building and in lending his great name to the building. So we are deeply indebted to all who brought about this facility. And as we have this wonderful lecture this evening, it's also an opportune moment to celebrate this building and all that has taken place within it. And what has taken place within it is extraordinary. The school has hosted 5 major European Research Council grants. These are the gold standard European Research Awards. And to host 5 in a law school of this size, this is more than any other law school of its size in Europe. So that is an incredible testament to the quality of work that goes on here in this building. And that has contributed more broadly to success in attracting the best faculty, the best students into our law school, which is very firmly in the top 100 law schools in the world. The Sutherland Fellows Visiting Scholar Scheme has attracted 63 scholars from all over the world, bringing their expertise and insights to our ongoing research across the school. And a real emphasis of the school, and I was delighted that Aisling spoke so positively about her experience in our access programs, a real emphasis in the school has been student supports and access. So we've now 7 ways of joining our undergraduate programs. Our student body is more diverse than ever before. And that is, again, thanks to many of the friends of the law school who have given such generous support through scholarships and bursaries within the school. So we are delighted to have such a wonderful school, as reflected in the group here today of alumni of the school, of faculty, of students, of supporters, and those who respect what goes on here. Obviously, we have extraordinary alumni in UCD, Sutherland Law School, or the law school more generally. Chief Justice Donal, delighted to have you with us, Chief Justice. Attorney General Rossa Fanning, some of our most distinguished alumni. And in Europe, very relevant to today's lecture, we have, as you know, the current President of the European Court of Human Rights, Siofra O'Leary, Judge Unani Rafferty, who is just appointed as the next Irish judge in the European Court of Human Rights, Michael O'Flaherty, the Council of Europe Commissioner for Human Rights, and this is to name, as you know, but a few. We have graduates of this school in every part of Irish legal life and lots of other parts of society. So it is wonderful to be able to welcome you here this evening for this lecture. You'll be hearing shortly about the lecture, about the late, great John Kelly, and how much would he have loved to be lecturing in this building with all the wonderful teaching that it enables, and to hear about Suzanne. And we greatly look forward to her lecture. And finally, again, I do want to thank, as I started with, Aisling and Robert for their words, because it is the students who are at the core of this building. The faculty do wonderful things, but we are always very much aware that it is our students who, as you said, Aisling, are the future of the legal profession and other professions within Ireland. We had another wonderful event this lunchtime in UCD. Dr. Anthony Fauci was with us for lunch, the chief medical officer from the pandemic period in the United States. He served 7 US presidents, and we had a wonderful conversation. Such an extraordinary, gracious and humble man, given his great learning and great achievements. And he was talking to various of our medical faculty and had great conversations, but he really lit up when he met the medical students who were in the room. And you can see that somebody like Dr. Fauci, someone of great eminence, for him, he recognises it is all about the students. And that is the case for us in the Sutherland Law School here this evening. So thanks to you all for being here. Thanks for your support of the law school here in UCD. Thanks for all that we do together to form the next generation. So I wish you a very enjoyable evening now, both the lecture and a glass of wine afterwards. Vermila Magav Galer.
Thank you very much, President. I shall now say a few words about the John M. Kelly lecture series, which honors the memory of Professor Kelly, who began his academic journey as a student in ancient classics at UCD. He went on then to study Roman law at the University of Heidelberg, from which he obtained a doctorate. Professor Kelly was called to the bar and practiced on the Leinster and Eastern circuits before returning to academic life as a lecturer and fellow at Trinity College, Oxford. A few years later, he was appointed professor of Roman law and jurisprudence in the Faculty of Law at UCD from 1965. Professor Kelly became Dean of Law at UCD just 2 years later. During the course of his distinguished academic career, Professor Kelly revived and edited the Irish Jurist, published several seminal texts which are all well known to most of us, including Fundamental Rights in Irish Law in 1968 and the Irish Constitution, which was first published in 1980. And True Story was the first Irish legal book I bought for myself when I first started working as a law lecturer in Galway. I'm not going to say when, even though I look young, still age is quickly catching up with me. I'm pleased to say also that alongside his academic career, Professor Kelly was also very active in politics, having served as a senator, a TD, a government minister, and as Attorney General. He retired from politics in 1989 and sadly passed away in 1991, aged just 59 years. It's my privilege to welcome some members of the Kelly family here this evening. On behalf of the School of Law, I would also like to thank Chief Justice O'Donnell and Justice Ireland for their generous involvement and assistance in actually helping us with the organization of the John M. Kelly lecture, which I'm pleased to say the School of Law has been has hosted for more than 20 years now. Without further delay, I will now give the floor to the Chief Justice to introduce this evening's distinguished speaker. Thank you very much.
President Feely, President of University College Dublin, Dean Pech, Dean of the Law School of University College Dublin, Attorney General, distinguished guests and friends. I regard it as an honour, a privilege and a pleasure to have the opportunity of introducing tonight's lecturer. Suzanne Kingston has had a stellar career, overcoming the initial hurdle and handicap of not attending University College Dublin as an undergraduate. She did her undergraduate degree indeed at Oxford University, where John Kelly studied. She obtained an LLM and PhD in the University of Leiden. She then also graduated from the King's Inns. She served as a referendaire in the Court of Justice of the European Communities. Prior to that, she practiced EU law in the Brussels office of an international law firm. She returned to Ireland and to UCD in 2007, where she was also came to the Irish bar in that year and took silk in 2020. She is her eminence is in part indicated by the number of visiting positions she has held, most recently as an international visiting professor of law and adjunct professor at Columbia Law School, New York. Previously held visiting positions at Cambridge University, the University of Leiden, Queen's University Belfast, and Osgoode Hall Law School, Toronto. As you've heard, she obtained one of the major research grants from the European Union's European Research Council in 2015, the gold standard of research, as President Feely has said. She was in 2022 appointed a judge in the General Court of the European Union. Now, and in that regard, as Professor Feely has said, she follows in a long line of very distinguished Irish lawyers who have flown the flag for Ireland in Europe. And as President Feely has said, this week is an appropriate week to celebrate that, because it's the week in which a graduate of this university and a colleague of mine, Ms. Justice Una Ní Rafferty, has just been appointed to the the European Court of Human Rights to succeed, indeed, President Siofra O'Leary, President of the European Court of Human Rights, also a graduate of this university. And all of those distinguished lawyers following, I think, in the path of trailblazing Irish lawyers like Mary Finlay Gagan, who's here today, one of the very first Irish lawyers to go and study European law. And I do tell my colleagues in Europe sometimes when they speak to me about the quality of the people who Ireland sends to Europe, and I say, please don't get the wrong impression. There isn't an inexhaustible supply of legal Amazons ready to come out and to illuminate European law, both in Luxembourg and in Strasbourg. But it is the case that we are enormously well served by the lawyers that have gone to Europe, Strasbourg, Luxembourg, elsewhere, dating back to the time when the European Convention of Human Rights was being negotiated, and Ireland sent its really best and brightest. Its negotiating team was Sean McBride, Cecil Laverty, later a judge of the Supreme Court, and F.H. Boland, perhaps the most distinguished of the Irish diplomats of the time, indeed the most distinguished Irish civil servants of the time. And Suzanne Kingston's career is an intersection that is particularly interesting to me and admirable to me, because it is an intersection between an academic career and a practicing career. It's particularly appropriate that the lecture tonight has been given in the Sutherland Law School, because Peter Sutherland blazed a trail for Irish law in Europe, and it's particularly appropriate that it's the John Kelly lecture, because John Kelly was perhaps one of the most brilliant people to teach in the law school in UCD at a time when facilities were a fraction of what is now available today. And the one thing that unites all those things, in my view, is the one thing that we all should pursue wherever we practice law, as academics or as practitioners or judges, or in Suzanne's case, as all three, whether at home or abroad. What unites all these things is a belief in the pursuit of excellence. And that is something Suzanne Kingston has done all her career. It's something that it is such a pleasure to observe from afar and admire from afar. She has shown the highest standards, both as a teacher, as an academic, as a practitioner. And I know, or I suspect, that she's going to repay this praise in the only correct way in a lecture like this, which is to subject some of the decisions of the Irish Supreme Court to piercing analysis, not to say criticism. So will you please welcome Suzanne Kingston.
Thank you very much, Chief Justice, Dean, distinguished guest, President Feely, Attorney General. It is really a great honour for me to be invited to give the Kelly Lecture. I have attended it many times, and Professor Kelly was, of course, as we've heard, really a giant of constitutional law. It's a great regret of mine that I never got the chance to meet him, but even now, I think more than 30 years after his death, I think his work still carries enormous relevance, including for the topic that I will be addressing tonight. I hope he would have approved of this evening's topic. I think it's a debate that would certainly have interested him, located as it is, I think, right at the interface between Irish, comparative, and EU constitutional law. And there is no doubt about it. Constitutional identity is really a hot topic. For some years now, the concept has given rise to a heated debate in the EU. Some have viewed it, as the title of my lecture alludes to, as a guiding light, or a sort of a chalk sullish, as we would see it, delimiting the boundaries of the EU and the national legal orders. Others have argued equally as vociferously that it is essentially an opportunity for constitutional relativism. Like the will of the wisp, it is argued that is a concept that cannot be definitively grasped. Whenever one gets close to capturing it, its essence slips away or vanishes it. Others have argued, indeed, in the wake of the controversial deployment of the concept by certain apex national constitutional courts, which I'll come to in a moment, that it is a positively dangerous constitutional concept and should in fact be done away with. So Federico Fabrini and Andres Sajo, for instance, argue that notwithstanding honest efforts of legal scholars to discipline constitutional identity, this concept is simply too mystical for the rule of law, too uncertain for European integration, and politically simply too risky in an increasingly populous Europe. It signals, they argue, that certain courts uttering identity are really reclaiming sovereignty. Now, in November 2002, of course, the topic became even more pertinent to those of us in Ireland as the Irish Supreme Court, or at least part of the Irish Supreme Court, invoked the concept for the first time in the well-known Costello case, ruling that it would be unconstitutional for Ireland to ratify the Canada-EU Comprehensive Economic and Trade Agreement, or CETA, as it's known. So what I hope to do tonight is to examine the concept as it has been used by national courts, including in the first instance, the Irish Supreme Court or certain judges of the Irish Supreme Court, but also thereafter by the Court of Justice of the European Union, where it has indeed been used in a line of landmark recent constitutional judgments to define the European Union's own constitutional identity. So there are three parts to my remarks tonight in that context. I propose to begin by, as I say, looking at the concept's development to date in Irish law thus far. I will then move on to consider the development of the concept in European Union law and in certain other member states. And then I'll conclude with some brief personal reflections on the discussion. So to start with looking at how this very young constitutional concept has been developing to date in Ireland, as I say, in certain judgments of the Supreme Court. And this is very much a moving target, and one is always conscious when one picks a topic that is very much in development, that there's still a lot left to be said on the topic. So one is looking at a relative newborn constitutional concept. It was introduced only 17 months ago in, as I say, the Costello case. Now, obviously, there are many significant aspects to the Costello case. The judgments are complex and much has already been written about it. But for today's purpose, I want to focus only on one aspect of, as I say, certain of the Supreme Court judges' reasonings, namely the introduction of and the reliance upon the concept of constitutional identity. Costello was a case, as the Chief Justice noted in his judgment, whose novelty is surpassed only by its importance. It will be recalled that Mr. Costello had argued that ratification by Ireland of CETA would be unconstitutional, in particular would be contrary to the provisions of the legislative power on the state in Articles 15 of the Constitution, and indeed of the administration of justice in Articles 34 and 37 of the Constitution. And the Supreme Court held by a majority judgments of 4-3 that Irish ratification of CETA in its current form would indeed be unconstitutional. Now, while the grounds of unconstitutionality varied between the majority, I think the common ground in the majority was that CETA ratification would breach Article 34 of the Constitution, because in particular, the awards of the CETA Tribunal could, in essence, as a result of the provisions of the Arbitration Act of 2010, be automatically enforced in Irish courts. And the Supreme Court majority held that the fact that the Court of Justice of the European Union had, for its part, held that CETA was compatible with the EU treaties in Opinion 1 of 17 did not, for the majority, change matters, because the competences covered by CETA are indeed only partially EU competences, the other part remaining purely a question of national law, so thus leaving a space for Irish constitutional law to apply in full. And by a majority of 6-1, the Supreme Court held that such unconstitutionality could, however, be cured by amendment, potentially, of the 2010 Act. Now, turning specifically to the concept of constitutional identity in Costello, it was referenced by 5 of the 7 judges, but in different terms and to different extents. And so I want to take a moment to look exactly at what was said on the matter. The Chief Justice and Power J in dissent referenced the concept only in passing, observing that in their view, nothing in the Arbitration Act 2010 would be contrary to the constitutional identity of the state. Baker J in the majority also referenced the doctrine, again only in passing, but reaching the contrary conclusion. And the principal substantive consideration of the doctrine is, I think, to be found in the judgments of Hogan J and McMenamin J, with the latter dissenting. So I want to take a moment to look at the judgment of Mr. Justice Hogan particularly on the topic of constitutional identity, because I think a lot of the Supreme Court's doctrine seems to come from that part of the judgment. So what Hogan J ruled was that Article 5 of the Constitution, as he put it, declares that the state is a sovereign and democratic state. Democracy is thus made an indispensable feature of the very constitutional identity of the state, and the provisions of Article 15.2.1, Article 16, Article 28.4, 29.5.2 and Article 47 are just some of the provisions of the Constitution which give practical effect to this commitment to democratic legitimacy and control. So the linkage of the constitutional identity in that portion of Hogan J's judgment is very clearly made to the democratic nature of the state, Article 5. In addition to this linkage to democracy, both McMenamin and Hogan J linked the doctrine to the sovereignty of the state in other passages of their judgments. On the scope next of constitutional identity, Mr. Justice Hogan further noted that the categories of awards that under CETA that would breach constitutional identity is, as he put it, perhaps never closed. It would, for example, he argued, embrace circumstances where the High Court considered that the CETA award proposed to be enforced was at odds in some material way with the legislative and juridical autonomy of the state. He also, it should be added, considered that the importance of enabling the High Court to refuse enforcement of a CETA tribunal award was necessitated not only by the need to protect Irish constitutional identity, but also by the need to respect our EU law obligations, holding that, and I quote, in particular, our obligation reflected in Article 29.4.4 of the Constitution to give effect to EU law, including the Charter of Fundamental Rights, and to preserve its coherence and integrity. For Mr. Justice McMenamin, he also considered, in addition to Article 5 of the Constitution, that Article 6 of the Constitution formed part of Ireland's constitutional identity. Notably, he expressly drew on the first line of the solais jurisprudence of the German Constitutional Court, and I'll come to that in a moment, to conclude that so long as, he argued, the protection of fundamental rights and constitutional identity are preserved in CETA, there will be no incompatibility between CETA and the Irish Constitution. Now, it is notable that since Costello, which again was only 17 months ago that was pronounced, certain judgments of the Supreme Court have reaffirmed on, by my estimation, some 6 occasions that the Constitution's Article 5 commitment to democracy and the democratic order are among the most fundamental features of the state's constitutional order and constitutional identity. And I'm quoting there from the Article 26 reference in the Judicial Appointments Commission's Bill 2022, judgment of 2023. We also see that appearing in the judgment of Mr. Justice Hogan in the McD case, in the Corcoran case, in the Adoption Act 2010 case also from last year and this year. To this conception of Irish constitutional identity has been added a reference to the rule of law in one case, the McD case, and also to democratic accountability in a further case. And that is the judgment of Mr. Justice Hogan in the very recent Delaney and Piab case of 9th of April last, which concerned the constitutionality of personal injury guidelines passed by the Judicial Council. In Hennigan, in addition, which concerned the constitutionality of the Shannon Electoral University Members Act 1937, Mr. Justice Hogan considered, moreover, that the process of constitutional amendment by means of referendum provided for in Articles 46 and 47 of the Constitution were perhaps, and I quote, the most fundamental and core feature of our constitutional identity as a state. So there are many different aspects in these different judgments, but there is a clear trend, I think, of this newborn constitutional concept coming through in a variety of very important judgments being handed down by the Supreme Court. And it is notable, I would add, that none of these latter cases after Costello concerned EU law in any significant way, I think. Most concerned wholly domestic issues without any particular aspect of EU law. One thinks of McD, Corcoran, Hennigan, the Adoption Act case, and Delaney indeed. Others were essentially questions of domestic law, albeit that certain EU law issues were discussed, the Judicial Appointments Commission Bill, Article 26 reference, for instance. So stepping back from that overview of what has gone on to date in the Irish context, I think we are in a really fascinating situation where a concept that, as we will see, has a fairly long pedigree in EU law has now apparently appeared in Irish constitutional law, but mainly indeed in purely domestic cases. Now, I say this with the major caveat, of course, there is no express recognition in those judgments of that source in any way, and one couldn't presume that it is coming in any way from EU law. Indeed, there may be some cross-fertilisation, but that is maybe all it is. There is certainly discussion of the Court of Justice principle of constitutional autonomy, of course, in the Costello case, and there is indeed, as I mentioned, a tantalising reference to a European heritage in the judgment of Mr. Justice McMenamin through his analogy with the solais jurisprudence of the German Constitutional Court in his judgment in Costello. But again, the relationship, or perhaps the transmogrification from the European concepts of constitutional identity to the Irish concept is not entirely clear. So the question indeed arises, are we talking about the same concept of constitutional identity as we have been talking about for some years in the European context? Does it have the same function? Or are we indeed talking about different animals, but with the same name tag, as it were? So with that, I'm going to turn to my second phase of the remarks, let's say, for tonight, which is to look indeed at the history of the doctrine before its insertion into the Irish Supreme Court jurisprudence with Costello, and to look at how the doctrine has developed to date outside the Irish context, the pedigree of the doctrine, European terms in particular. And indeed, when one does that, one sees quite rapidly that there is more than meets the eye with this concept of constitutional identity. It is a complex concept, and there is in fact no agreement, even now in European terms, when one sees it has been used for at least 30 years, and indeed more than that. There is no agreement on the precise function, nor indeed on the scope of the concept of constitutional or national identity, as it's sometimes called. however, comes with, I think, what it's fair to say, some conceptual baggage. As I mentioned at the outset of today's remarks, it already has some, let's say, supporters and some who are fervently against the concept for reasons that I'll explain. Investigating the concept further, it is clear that it has deep historical meanings and a long pedigree. In the US, for instance, there has been for years a vivid debate among a range of distinguished scholars about the utility of the concept of constitutional identity in the context of the US Constitution. Some distinguished scholars, such as Lawrence Tribe, for instance, claiming that it is too subjective to be of any significant utility. Others, equally distinguished scholars, such as Joseph Raz, for instance, arguing that it is necessarily a dynamic concept and does not necessarily tie courts to seeking the intentions of the authors of the US Constitution in any originalist way. But as I say, closer to home, in particular within Europe, the concept has received very significant attention, both in the judgments of the Court of Justice of the European Union, but also in a variety of national courts of EU member states, particularly in the past decade, it must be said. However, its roots in EU law and before certain national jurisdictions go back, as I say, much further. In fact, it appeared in the Treaty of the European Union at the very outset of that treaty. So the creation of the European Union as such, as distinct from the European Economic Community, brought with it indeed the inclusion of national identity, constitutional identity, included in the TU from the outset. This was included in the Treaty of Maastricht. Article F1 of the Treaty of Maastricht provided that, and I quote, "The Union shall respect the national identities of its member states whose systems of government are founded on the principles of democracy." So that was the original codification, as it were, at treaties of primary law level of the principle of national identity in the Treaty of European Union. So it was there from the outset within the formation of the EU. And it should be said that this formed part of a broader move to express certain constitutional tenets, so fundamental constitutional principles expressly in the TEU, expressly in the Maastricht Treaty. And these were broadly aimed at addressing for the first time a problem which within EU scholarship is often called competence creep. The idea that without expressly including constitutional principles limiting the outer boundaries of the EU's competences, the EU's competence would gradually expand and expand. And so these other provisions included at the same time with the Treaty of Maastricht included, for instance, the express inclusion for the first time of respect for fundamental rights as a foundational principle of the EU, but also the first inclusion of the principle of subsidiarity within the treaty, alongside the first inclusion of the national identity principle. Part of the context for this was, of course, the reaction of certain national courts to Court of Justice case law, establishing certain fundamental principles of EU constitutional law, including in particular the Court of Justice's 1973 ruling in the Internationale Handelsgesellschaft case that the doctrine of supremacy of EU law also applied to conflicts with national fundamental constitutional rights. And it should be said, and this audience will be well aware of the fact that from the 1970s, certain constitutional courts in some member states, notably the Bundesverfassungsgericht, the Federal Constitutional Court in Germany, in the Solanga I case, and also the Italian Constitutional Court in the Frontini case, through its doctrine of contro limiti, had indicated that from their perspective, there may be some constitutional limits to this supremacy that was being declared by the Court of Justice in Luxembourg, notably in case of conflict with national fundamental rights. Although it is also true, of course, that well before the Maastricht Treaty, the Court of Justice of the European Union had emphasised, indeed in its own case law, that respect for fundamental rights also formed a general principle of the EEC legal order. Now, I pause here to observe that while 1992, so the Maastricht Treaty, was therefore the first express inclusion of the national identity principle in the treaties, in the TEU, As Advocate General Maduro rightly observed in his 2008 opinion in the Mikaniki case, in reality, the obligation to respect national constitutional identities, as he put it, has existed from the outset. It indeed forms part of the very essence of the European project, initiated at the beginning of the 1950s, which consists of following the path of integration whilst maintaining the political existence of the states. And one might add to that observation that the economic focus of the initial Treaty of Rome meant necessarily, of course, that few constitutional principles in that sense were included in the treaty at all. But these were nevertheless found to be implicit through the development of general principles by the Court of Justice in particular. It is also worth noting that from the outset, the Maastricht principle of national identity was, as we've seen, expressly linked to national systems of government founded on the principles of democracy. So I think we can see that from the very outset at EU level, the concept of constitutional identity has really been linked to the concept of democracy. And this echoes the concept that we saw in certain of the judgments, I think, in the Costello case. It's a linkage that therefore has been there for over 30 years, in fact, in the EU treaty, although, as I'll discuss in a minute, it has been invoked in very many different contexts by certain constitutional courts since then. So moving on from Maastricht, it was only with the constitutional treaty, the doomed constitutional treaty 8 years later, that the national identity principle was expanded and elaborated upon at EU level. And this specified that, and I'm quoting because it's the same version that we still have after the Treaty of Lisbon, the Union shall respect the national identities of the member states inherent in their fundamental structures, political and constitutional, inclusive of regional and local self-government. And I also note that the preamble to the Charter of Fundamental Rights similarly refers to the concept. So it states that the Union contributes to the preservation and the development of the common values of the EU while respecting the national identities of the member state. So we can see that with the constitutional treaty language, there was an effort to add further meat to the bones of this kind of sketch of a concept of national identity that was there in Maastricht. And indeed, if one looks at the travaux préparatoires of the constitutional treaty, one sees that the impetus for this expanded national identity clause, which had been proposed by the chair of the working group on so-called complementary competences, Mr. Henning Christoffersen, who was a Danish politician who had been vice president of the European Commission. The aim was essentially to improve transparency and conceptual clarity. In other words, the idea was to better explain what this rather ambiguous concept of national identity was all about. As we know, the constitutional treaty itself died an early death. It was rejected by the Dutch and the French voters, notably by referenda. But this version of national identity was, as I say, essentially retained in what is now Article 4.2 of the Lisbon Treaty in 2009, and it remains the version in force today. And I also just note that by its wording, constitutional identity is expressed to be one of the aspects of national identity, which is defined as I say, member states' fundamental structures, political and constitutional. So in looking at the relationship between national and constitutional identity, it is clear from the text of Article 4.2 TEU that national identity and constitutional identity can in fact, and one sees this in the case law, be used relatively interchangeably. Constitutional identity is seen as being one component of national identity, as it's seen in Article 4.2. So how then has the Court of Justice interpreted the concept of constitutional identity? As I mentioned, this has evolved over the years. It started with a trickle of early cases, but the number has been rapidly increasing, as it must be said, certain member states have sought to invoke it on an increasing number of occasions, particularly after the Lisbon Treaty and in a very wide set of circumstances. But indeed, Ireland itself was at the centre of one of the earliest successful invocations of the concept, even before the Maastricht Treaty, in the famous Anita Gruner case of 1989, and many of you will be familiar with this case. It was a case where a Dutch national challenged the Minister for Education for refusing to appoint her as an art teacher because she had failed an Irish language test. And she argued this was contrary to the free movement of workers. And a reference to the High Court, the Court of Justice, however, gave short shrift to Ms. Gruner's argument, noting that proportionate restrictions to free movement were justified, given that Bunreacht na hÉireann provides that Irish is to be the national language and the first official language, and given that Irish governments had in fact for years pursued a policy of promoting the Irish language. That the Gruner judgment was delivered some years before the insertion of the national identity concept into the treaty indeed demonstrates, I think, that the Court of Justice was very alive to constitutional identity and its importance and the sensitivities around national constitutional identities well before the treaty amendments. And since then, indeed, the Court of Justice has accepted constitutional identity justifications, notably for restrictions of EU free movement rules in a variety of other cases. One could mention here, for instance, its recognition of the fundamental German constitutional principle of respect for human dignity, Article 1 of the German Constitution, in the Omega judgment. Also, its recognition of the importance of the Austrian constitutional rule abolishing nobility in the Sein-Wittgenstein case. Now, I think it's fair to say what is common to these cases of the Court of Justice is that the court's acceptance that there was a genuine constitutional tradition at stake in the member state was very important. It looked at the fact that this was a genuine constitutional tradition that was in fact of import to the state. These were cases also where the constitutional identity value at issue did not compromise a field that had been harmonised by European Union law or impact free movement, in particular, in a disproportionate manner. So aside from those successful invocations of the constitutional identity principle, other attempted invocations of the principle, and there have, as I say, been many, have not fared so well. In its 2018 Grand Chamber judgment in the Coman case, for instance, the Court of Justice rejected Romania's claim that it was precluded by its own national identity from interpreting the concept of spouse within the meaning of the Directive on Union Citizens Free Movement, Directive 2004-38, to include same-sex spouses of a union citizen. Now, in that case, Romania argued in particular that it did not provide for same-sex marriages under its national law. And the Court of Justice, in its response, while recalling the provisions of Article 4.2 TEU, the National Identity Principle, it was very clear that as the obligation under the Free Movement Directive required Romania only to grant a derived right of residence to Mr. Coman, there was no obligation for Romania to provide for same-sex marriages in its national law. And so in the circumstances, it ruled that an obligation to recognise such marriages for the sole purpose of granting such a derived right of residence to a third country national did not, it ruled, undermine the national identity or pose a threat to the public policy of the member states concerned. Aside from Coman, more recently, the question of constitutional identity arose in a very interesting manner, I think, in the Commune Danse case, which concerned a Belgian commune's prohibition on its workers from wearing any visible sign which might reveal their religious beliefs. Now, the claimant in that case, who worked in the back office of the commune, requested to wear a headscarf at work, and this request was refused. And the case, therefore, raised the very sensitive issue of laïcité or state neutrality, which is, as you know, in certain member states, notably France, a fundamental constitutional concept. Intriguingly, in the Commune Danse case, as the opinion of Advocate General Collins in that case explains, while the issue of constitutional identity was raised by the referring Belgian court before the Court of Justice, Belgium neither made any written submissions on the matter nor even attended the hearing. And there did not, as the Court of Justice observed, appear to be any constitutional definition of the scope and content of the principle of state neutrality, laïcité, in the Belgian constitution. Conversely, it was France who intervened and made considerable submissions on the question. So in that case, despite the sensitivity of laïcité in general, there was no reason on the facts of the case before the court to accord weight to constitutional identity. And indeed, the concept was not really mentioned at all in the ultimate judgment of the court. And I think what this case shows is that claims of constitutional identity cannot, under the Court of Justice's case law, be made in general terms. They must be supported by the constitutional facts of the case made before the court. As in the Glerner case, for instance, the Irish government arguing in that case that there had been a consistent policy of support for the Irish language. But certainly, I think the most striking recent developments in the Court of Justice's approach to national constitutional identity is evident, as we know, in the Court of Justice's recent judgments on the rule of law and judicial independence. And as this audience will be aware, the Court of Justice has dealt with a number of cases in recent years, raising issue about the rule of law and the independence of judges in particular, notably in relation to Poland and Hungary. In many of these cases, arguments of national identity have been based in essence on the different constitutional and judicial structures in the member state at issue. And I think what you see in the Court of Justice's rejection of these arguments is that in doing so, the Court of Justice has used the opportunity to define for the first time the Union's own constitutional identity, and linking this, as we'll see in a moment, closely to the concept of the autonomy of EU law. Now, perhaps the clearest example of this is the 2022 conditionality judgments of the Court of Justice, where the full court of the Court of Justice ruled that the limits of constitutional identity are reached in cases of conflict with Article 2 TEU foundational values. So these are respect for human dignity, freedom, democracy, equality, the rule of law, and human rights. And I just pause to note that it is only in very exceptional circumstances that the Court of Justice chooses to sit as a full court with all 27 judges. It is very rare, and that demonstrates and illustrates the fact that this was a crucially important constitutional case from the perspective of the Court of Justice. So what the Court of Justice says in the conditionality judgment on constitutionality, on constitutional identity is, I think, vitally important. So the case involved actions brought by Hungary and Poland against the conditionality mechanism contained in an EU regulation, Regulation 2020 of 2092, which made the receipt of financing from the Union budget subject to member states' respect for the rule of law. And in dismissing the actions, the Court of Justice rejected in particular Hungary's argument that the conditionality mechanism would compromise its own national identity, notably the specific structure of its own legal system. But the Court of Justice went further, as I say, and went on to define the Union's own constitutional identity, drawing in particular on its previous case law, such as the Republica case. And the crucial passage in the conditionality judgment is at paragraphs 125 to 127. I'm not going to read them out in full, but I do want to read out some vital excerpts from that portion, because I think it really explains how the court is conceptualizing Union constitutional identity and how it interrelates with national identity. So what the court rules in these paragraphs is that once a candidate state becomes a member state, it joins a legal structure that is based on the fundamental premise that each member state shares with all the other member states and recognises that they share with it the common values contained in Article 2 TEU, on which the European Union is founded. That premise, the court continues, is based on the specific and essential characteristics of EU law, which stem from the very nature of EU law and the autonomy it enjoys in relation to the laws of the member states and to international law. That premise, the court ruled, implies and justifies the existence of mutual trust between the member states that these values will be recognised, and therefore that EU law that implements them will be respected. It follows, the court ruled, that compliance by a member state with the values contained in Article 2 TEU is a condition for the enjoyment of all the rights deriving from the application of the treaties to that member state. And the court continued at 127 that the values contained in Article 2 TEU have been identified and are shared by the member states. They define the very identity of the European Union as a common legal order. And thus, the European Union must be able to defend these values within the limits of its powers as laid down by the treaties. The court continued to rule that this very definition of the Union's own constitutional identity entailed inexorably, in the Court of Justice's view, rejection of Hungary's national identity arguments. So at paragraph 234, the court ruled that while they have separate national identities inherent in their fundamental structures, political and constitutional, which the European Union respects, the member states adhere to a concept of the rule of law which they share as a value common to their own constitutional traditions and which they have undertaken to respect at all times. Now, as I say, I think these paragraphs are really central to the court's judgment, and they encapsulate, I think, a very definite and I think a powerful vision of the Union's constitutional identity and its linkage with other constitutional doctrines that it has developed over the years, including the principle of autonomy, but also the principle of mutual trust. So the premise of recognising and sharing common Article 2 TEU values implies, the court rules, and justifies the doctrine of mutual trust, but all are said to derive from what the court calls the specific and essential characteristics of EU law, deriving from its autonomy vis-à-vis national law and international law. So one can see, therefore, very clearly in the conditionality judgment that the Union's constitutional identity is therefore ultimately linked and intimately linked to the central foundational concept of the autonomy of Union law. And one can also, it should be added, see this in other case law. So the leitmotif of autonomy serves increasingly to explain not only the fundamental constitutional judgments defining the Union's constitutional identity vis-à-vis that of its member states, so the rule of law cases in particular, but also its fundamental constitutional judgments defining the limits of the EU's participation in international organisations. And I'm speaking here, of course, about the Court of Justice's very important rulings in Opinion 213 on accession to the European Convention of Human Rights, where the Court of Justice held that accession would not respect the autonomy of Union law, notably that of its judicial system, but also Opinion 117, where it reached, in fact, the opposite conclusion in relation to CETA. Conversely, the Court of Justice has linked the rejection of national identity arguments to the definition of the Union's own constitutional identity based on Article 2 values, while at the same time seeking to reassure member states that it doesn't have any one-size-fits-all conception of these values, notably in defining the rule of law. So you can see this in conditionality, in the conditionality judgment, of course. You also see it in the Romanian cases, the Eurobox and the RS case, where the court ruled the rule of law in the EU does not seek to impose, and I quote, a particular constitutional model to which all member states must aspire. This would be contrary to the principle of respect for national identity. So on the contrary, it would seem that I think the Court of Justice's approach is ultimately founded on a certain overarching theory of constitutional pluralism. As President Leenaerts, President of the Court of Justice, has argued extrajudicially, in protecting and promoting liberal values, the principle of autonomy enables the EU to find its own identity whilst allowing for openness towards the law of the member states and also to international law. So this is, I think, the Court of Justice's view of constitutional identity as it has evolved over the years. But in a legal order composed of a plurality of constitutions, that is, of course, only one part of the picture. And so it's to the rest of the picture that I now want to turn. And that is, of course, the case law of certain national courts on the issue of constitutional or national identity. And as we know, as this audience knows very well, a rich and indeed complex case law on constitutional identity has emerged from certain national constitutional and apex courts over the years, in particular also in the last decade. It is impossible to do full justice to it in the few minutes that I have available tonight, but it does, I think, form a vital part of, let's say, the Costello development. So the development, it forms a vital part of the context for the Costello development of the concept before the Irish Supreme Court. It's an important part of the picture, so it is important to look at it, even if only partially. And I think one can distinguish here between different lines of national case law, indicating, as I would see it, slightly different conceptions of national and constitutional identity and different functions of the concept. So I'll start with first what might be termed the classic national constitutional case law, which concerned, as I mentioned at the outset, national fundamental rights traditions. And as I mentioned, this is in a sense where all of this debate started right back in the 1970s with Internationale Handelsgesellschaft, and that sparking the concern of certain national constitutional courts that EU law wouldn't adequately account for their own specific national fundamental rights traditions, or indeed account adequately for fundamental rights protection at all. And ultimately, a balance was reached, as we know, whereby, in particular, in the case of the German constitutional courts, it accepts not to review EU law for compatibility with German constitutional rights so long as the EU regime guarantees overall an equivalent level of protection of fundamental rights. We see this in Solanga too. We also see it in the jurisprudence of the Italian Constitutional Court. However, it should be noted that even within this fundamental rights strand of national constitutional identity, and even after the 2009 incorporation of the EU Charter as primary law with the Treaty of Lisbon, this has remained a vivid debate in cases where national courts have sought to maintain a higher level of national fundamental rights protection in particular. And it has notably been so in the area of the European arrest warrant. It should be said, the Court of Justice's robust statement in a 2013 judgment in Maloney that national courts may apply national fundamental rights standards only to the extent that it would not affect the primacy, unity and effectiveness of European law, was met upon its return, for instance, to the Spanish Constitutional Court with the response in its 2014 judgment that it would do so, but only insofar as it would not conflict indeed with Spanish constitutional identity. And one can see very clearly in the case law that data protection, for instance, has been a similarly sensitive area for certain national courts, in particular the French Conseil Constitutionnel. And sticking with this fundamental rights aspect of national identity and coming closer to home, one can see that this kind of constitutional identity claim was arguably also evident in the SPUC and Grogan case, which, as we know, concerned the interaction between the right to life of the unborn and free movement of services under EU law. Now, as will be recalled, in that case, Carol J. refused to grant an interlocutory injunction prohibiting the distribution of information on abortion services in the United Kingdom, and she referred a question to the Court of Justice of the European Union on whether this was compatible with a woman's right to travel to receive services in another member state under community law, as it was then. But on appeal of that refusal of the interlocutory injunction to the Supreme Court, Mr. Justice Walsh was clear that the Court of Justice's answer will, and I quote, have to be considered in the light of our own constitutional provisions. In the last analysis, he ruled, only the Supreme Court could finally decide what the effects of the interaction between the two constitutional provisions at issue, notably Article 43.3 and what is now Article 29.4.6, were. And ultimately, as we know, the Court of Justice obligingly avoided answering the question directly on remoteness grounds, and the Constitution was, of course, subsequently amended and the article in question was repealed. Nevertheless, this can be, I think, fairly inserted within the fundamental rights line of the national identity case law that one sees coming from national apex courts over the years. I want to then move on to the other broad category of national identity review that has been very much discussed in the literature and indeed before the courts over the recent years. And that is what is sometimes called identity review. It is sometimes seen as being also including within it the concept of so-called ultra vires review. Now, both of these forms of review that has been developed by certain national constitutional courts are perhaps both most well known from the case law, again, of the German Constitutional Court. So you'll forgive me for looking just very briefly at how the German Constitutional Court has developed these dual concepts of identity review and ultra vires review, because these are new ways of reviewing the relationship between national constitutional law and EU law that are very relevant for understanding the concept of constitutional identity. And an important part of the context for this case law of the German Constitutional Court is the fact, I think, that the German Constitution contains a so-called eternity clause, so an Ewigkeit guarantee, set out in Article 79(3) of the German Constitution, that makes it impossible in terms to amend certain fundamental provisions of the Constitution. And obviously there are important historical reasons for the way that the German Constitution is constructed. And these fundamental provisions of the Constitution include, in particular, Article 1, which I mentioned earlier, recognising human dignity and human rights as inviolable, and also Article 20 of the German Constitution, setting out the principles of democracy, sovereignty and the rule of law. And by Article 23 of the German Constitution, the establishment of the EU and changes in its treaty foundations must comply with the eternity clause. So within German constitutional scholarship, it is explained that in German constitutional law, EU legal acts must therefore remain within the limits of this constitutional authorization for integration. And these limits are policed indeed by these two concepts of review that I've mentioned, the ultra vires review and the review for constitutional identity. So in particular, since its 1993 Maastricht decision, the German Constitutional Court has in essence developed a doctrine of ultra vires review. It was originally in that decision linked to the principle of democracy, which is protected, as I say, by the eternity clause. In Maastricht, the German Constitutional Court essentially held that as the powers transferred to the EU derived ultimately from the member states as the original, as they put it, constituent power, the power to review whether the EU remained in the limits of these competences remained with the member states, and in the case of Germany, with the German Constitutional Court. And this is the famous competence debate. It's a conundrum. Who has the competence to decide about where the limits of competences are between the EU and the member state? To this form of review developed in the Maastricht judgment, again, ultra vires review was added with the 2009 Lisbon and subsequently OMT judgments, the concept of, as I've mentioned, identity review. And the German Constitutional Court essentially linked this again to the eternity clause, which it considered to identify core areas of German statehood fundamental to its democracy, and which constituted, therefore, it ruled, an absolute limit to participation in the EU. At the same time, in its Lisbon judgment, and indeed in subsequent cases, it has emphasised that identity review can only be done in a spirit of sincere cooperation and openness towards EU law, so Europarechtsfreundlichkeit. This did not, however, prevent the German Constitutional Court from finding in its 2020 PSPP judgment on the legality of the ECB's public sector purchase programme, and following a preliminary reference, it should be said, to the Court of Justice on the matter, the Vice ruling, that the ECB's decision and indeed the Court of Justice's Vice judgment in itself were ultra vires acts in violation of German constitutional identity. Now, it is fair to say that the PSPP judgment of the German Constitutional Court was very controversial. It led ultimately to an infringement action being opened against Germany by the European Commission. And ultimately, the matter was resolved indeed at a political level when the German Parliament passed a resolution confirming, after receiving further information from the ECB, that the PSPP did in fact comply with the conditions set out by the German Constitutional Court. Nevertheless, the German Constitutional Court's constitutional identity jurisprudence has over time been very influential, it must be said, in the development of various shades of identity review and ultra vires review in a number of member states, including France, Spain, Poland, even before the recent reforms, which have been controversial, but also, in fact, in Denmark, Cyprus, the Czech Republic, for instance, in the sugar quotas case. Now, aside from the PSPP judgment of the German Constitutional Court, identity review has, it must be said, often remained hypothetical in the case law of the various national apex courts, and direct clashes with the Court of Justice have in most cases been avoided. In a limited number of cases, it must be said, the application of national identity has in fact led to such full frontal clashes. And this occurred, for instance, with the 2020 ruling of the Romanian Constitutional Court, holding that by virtue of the specific nature of, again, the Romanian constitution, national courts did not have the power to examine the compatibility of domestic law with EU law, where a national law had been declared constitutional by the Romanian Constitutional Court. There have also, of course, been well-documented clashes with the Polish Constitutional Tribunal, particularly the newly constituted tribunal, which held in its 2021 P720 judgment that the Court of Justice's interim measures against the controversial disciplinary chamber of the Polish Supreme Court were ultra vires. And ultimately, in its 2021 K321 judgment, invoking the Article 4.2 TEU national identity wording, where the Polish Constitutional Tribunal held that Article 1 TEU, along with Articles 2, 4.3 and 19 TEU, were indeed unconstitutional under the Polish Constitution, insofar as they allowed national judges to raise issues about national judicial independence. This was therefore clearly a full confrontation with the Court of Justice and its interpretation of the TEU's values, and in fairness, it was widely criticised as an abuse of constitutional identity. Now, against this, and to finish off in our quick tour of national apex court jurisprudence on national constitutional identity, one also, it should be emphasised, sees constructive and dialogue-based uses of the constitutional identity concept. And a recent important example, I think, is the Taricco cases, which were before the Italian Constitutional Court and also went before the Court of Justice of the European Union. And there, the CJU had held on an initial reference in 2015 that Italian courts should disapply national limitation rules where necessary to prosecute tax offences damaging the EU's financial interests. Now, when the matter came back before it, the Italian Constitutional Court referred, in fact, a further reference to the Court of Justice, questioning the compatibility of that first Taricco judgment with the principle of legality under Italian constitutional law, and noting that the Italian Constitution appeared to have a higher level of fundamental rights protection in this regard than the EU Charter. So, in essence, what the Italian Constitutional Court did in the Taricco line of cases was to invite the Court of Justice to reconsider its position. And that is precisely what the Court of Justice did in its 2017 second judgment, the MAS judgment, indicating that in its first judgment, it had not in fact been informed of certain relevant aspects of the Italian constitutional system. So all of that brings us, no doubt you will be extremely relieved to hear, to the final part of my remarks. Having taken this whistle-stop tour, starting in Dublin, moving to Luxembourg, and pausing briefly in Karlsruhe, Paris, Bucharest, Warsaw, and indeed Rome, what broad conclusions might be drawn about this enigmatic concept of constitutional identity and its function, its usefulness and limitations? It is, I think it is evident to all of us here this evening, it's a huge debate. I'm going to limit myself to a few very brief personal reflections. Firstly, while I'm very conscious of criticisms of the concept as being open to abuse, we've already seen some examples in which that has occurred. I think that the concept of constitutional identity is here to stay. For EU member states, as we've seen, it is in fact a part of EU constitutional law. It is there, for better or for worse, in Article 4.2 TU. And I think that the treaty authors inserted it for good reason. It is a recognition of the need for a certain flexibility between national and EU constitutional orders, and the need to account for genuine, vital constitutional differences. If you want, it is a necessary point of articulation between the EU and national legal orders. Even if it is also true that it is a doctrine to be handled with care. And yes, it is possible for the doctrine to be abused. We have seen examples of that even this evening. And even in some case, it may be thought that this was done very much intentionally on the part of certain of the apex courts. But I would argue that even if it could be said that some of that abuse was indeed intentional, it might be thought that if constitutional identity wasn't, let's say, the pretext for reaching a desired result, then another constitutional concept would be found to do the very same thing. So in other words, I think that putting all of the blame on the concept of constitutionality is perhaps unfair in that context. What is also clear, however, is that the concept of constitutional identity has limits. This is very clear from the Court of Justice's conditionality judgment, where, as we've seen, the Court of Justice defined its own constitutional identity, so the Union's constitutional identity based on Article 2 TU values: human dignity, freedom, equality, the rule of law, respect for fundamental rights. This is, as some have put it, the Union's constitutional DNA. It is its special or autonomous nature. And I think it is by definition, and the Court of Justice made that clear in the constitutionality judgment, it is by definition shared with member states. These are by definition common values, as they are preconditions for accession, indeed, to the Union. And ultimately, I think, therefore, this process of defining the Union's constitutional identity does not, in fact, seek to exclude national constitutional identity, but rather to reinforce these common fundamental values, which are, in truth, DNA shared with all member states. I think these cases from the Court of Justice represent a very important positive expression of fundamental EU values. And I also think that the Costello line of cases, so the birth of an Irish conception of constitutional identity, re-emphasises the centrality of these values, in particular democracy, to the Irish Constitution. I think this can be said to be a double reinforcement of the effect at EU and at national level of what are, as I say, in truth, common fundamental values. So I think that the introduction of the concept represents the Supreme Court stepping up to contribute to this dialogue that is, as we've seen, already vibrant in Europe, and indeed reinforcing this commonality of fundamental values. Secondly, it's perhaps an obvious point, but the difficulties of these, what I've described as full frontal clashes between the EU and national constitutional law norms of the type that has arisen in, for instance, Germany and Poland, These are inherently less likely in Ireland due, of course, to the presence of Article 29(4)(6) in our Constitution, which essentially, as we know, gives constitutional immunity to all acts necessitated by the obligations of EU member states. Now, of course, this did not resolve the matter in the CETA case, the Costello case, because CETA was not so necessitated due to the fact that part of it concerned the shared competence with the EU. And as Gavin Barrett, my colleague, has noted, there is, of course, no eternity clause of the kind we looked at in the German constitution in Bunrat na hÉireann, excluding certain constitutional provisions from the application of Article 29(4)(6) due to their inalienable nature. On the contrary, indeed, the Supreme Court has, in its prior case law, rejected the concept of unamendability. The State Ryan and Lennon, for instance, the Article 26 Abortion Information Services cases, and holding that constitutional amendment approved by the people cannot be unconstitutional. And indeed, in the Irish context, for instance, one particular and distinctive constitutional feature that is often cited is precisely the importance of popular sovereignty. So the need for referenda for constitutional amendment, including as interpreted in the Crotty and Pringle cases in the case of significant EU treaty amendment. So I think all of this certainly means that clashes of primary union law and Irish constitutional law are indeed less likely, although it should be added in principle not a priori excluded. If, for instance, there was a clash between a constitutional provision, for instance, one found to form part of Irish constitutional identity and Article 29(4)(6) in the future. And remember, this was in essence the hypothesis that was posited by Mr. Justice Walsh in the Grogan case. But of course, the Costello doctrine of constitutional identity is the inverse. It's about common constitutional identity values. It does not answer the question about potentially distinctive features of the Irish Constitution, which are not shared by the EU legal order or necessarily by most other member states. Indeed, as we've seen from the Court of Justice's case law, the Court of Justice has accepted such arguments in certain cases, notably, as I mentioned earlier, where there is a genuine particular feature of constitutional identity that does not clash with core EU values. And in truth, it could be said in such circumstances, there is no clash at all, because what the Court of Justice has done is to accept the national value at issue as entirely compatible with EU law, as in Gruner, for instance. And here again, as I say, national case law may be, I think, vitally important in clearly showing that the constitutional value at issue is in practice genuine and important at national constitutional level. Think of, for instance, the Belgian case, the Commandant's case about the headscarves. Conversely, while writing in the 1960s and 1970s, Professor Kelly rightly observed at that time that a distinctive constitutional approach to religion and natural law was evident in the Supreme Court's case law of that time, for instance, in the judgment of Mr. Justice Walsh in the McGee case. One might suppose that if such an argument were raised today, it would rather be considered in the light of the current Supreme Court case law. And so one could put it that the constitutional DNA of a state, as interpreted by the courts, may indeed evolve over time. And third and finally, I do not deny that the concept gives rise to certain difficult conceptual questions that will certainly need to be further worked out in the case law. It is true, for instance, that in a constitution without any eternity clause, as in the German constitution, or any article indeed expressly defining its core values, as in Article 2 TEU, claims of subjectivity or legal uncertainty may arise, such as those raised by Lawrence Tribe in the UN's context, and indeed by Aaron Doyle closer to home. How can one know what the core is on the periphery? Must one then include the entirety of the Constitution, lest this give rise to some kind of illegitimate ranking of constitutional provisions without textual basis? These are all important questions, and I just think deserve careful consideration, and it may be thought further explanation and justification in the case law. But to conclude, I think this is perhaps to be expected for indeed a young constitutional doctrine, and further reasoning on this is, one senses, yet to come. One cannot but wonder, Chief Justice, Dean, what Professor Kelly would have made of it all. Thank you.